The protection of trade secrets is a really interesting topic, and it's one that we're seeing clients seek advice on more and more.
So Mike, you've worked in this area with clients for many years now, haven't you?
That's right. As we see economies shift to a more knowledge-based economy, we're seeing that the protection of trade secrets is so much more important as businesses rely on their proprietary know-how as a way of differentiating their businesses and getting ahead of the competition. So protecting valuable trade secrets is a really important part of achieving that.
So Mike, what's the state of play in the UK? Because the EU Trade Secrets Directive was introduced pre-Brexit, right? So that will have had some sort of impact on the law in the UK?
Yeah, that's right. So the EU Trade Secrets Directive came into force in 2016, and we actually implemented it here in 2018 under the Trade Secrets Enforcement Regulations. So they still apply today post-Brexit. The regulations define a trade secret as information which is secret, in the sense that it's not available or readily available to those who would usually be interested in that information. It's information that's commercially valuable because it's secret, and reasonable steps have been taken to make sure it's kept secret. The regulations are really helpful because where an infringement's found, the courts have got a number of powers. For example, they can impose injunctions preventing further use and dissemination of that information, orders for the destruction of infringing articles, and other corrective measures such as publicity notices, that sort of thing.
So that sounds really interesting, but it doesn't sound too different from the equitable principle of confidential information under English common law. What are the differences between the two?
Yeah, you're right. So I suppose it's fair to say that the EU Trade Secrets Directive was a bit of a levelling up exercise for member states in the EU. In the UK, we for a long time already had a common law doctrine which protected rights in confidential information. Under that doctrine, the requirements were that the information was confidential in the sense of the nature of the information itself, that it had been shared in circumstances where it was clear that it was being imparted in confidential circumstances, whether that was an express or implied obligation of confidence, and that there had been misuse of the information and that had harmed the rights owner in some way. So I suppose in many ways we already had a framework that protected confidential information and by extension trade secrets in this jurisdiction, albeit we didn't have those additional requirements of it being valuable because it was secret, or the requirement to take reasonable steps to protect the secrecy of it.
So Mike, does that mean that the Trade Secrets Directive hasn't made much of a practical impact on the level of trade secrets protection in the UK?
Yeah, in some senses I think that's probably right. There's been limited reported cases involving claims under the trade secret regulations. And in my experience, a claimant will usually bring a parallel claim both under the equitable doctrine on the one hand and the regulation on the other. So those two claims will usually go hand in hand. And as far as I'm aware, there isn't a reported case at least where a claim under the regulation has succeeded where the equitable claim hasn't. So I suppose for practical purposes, it hasn't made a great deal of difference, at least in terms of how things have played out in front of the courts. I guess from my perspective, what the Trade Secrets Regulation has really brought about is a nice framework to give businesses an idea of how they should be really looking to protect their trade secrets internally.
Okay, Mike, I see what you mean. So the requirements to demonstrate value and that reasonable steps have been taken to preserve the secrecy of information are really good things from a business best practice point of view.
Yeah, absolutely. I mean, it's fair to say that capturing know-how at the point of creation is really difficult within businesses. So having policies in place which demonstrate those two things could be really valuable.
Okay, so that makes sense. In terms of employee inventions, it's useful to have good record keeping when employees develop valuable inventions for the business?
Yeah, that's right. I think the key thing is to have policies in place which help to record those things as you go along. So you're capturing innovation and important internal know-how as it's being developed.
Okay, and from a data security perspective, you want to regularly test and monitor the business's procedures.
Exactly.
So Mike, it sounds like the framework and the protections offered by both the trade secrets regulations and the common law rights and confidential information are both really useful tools for businesses to have in their bag.
Yeah, I think that's absolutely right. And the phrase sort of tools in the bag is a really good one because of course there are other rights that you might also want to consider. Contractual obligations around confidentiality, for example, copyright, and other rights under legislation like the Computer Misuse Act, for example. I think all situations are going to depend on the particular circumstances, so you just need to have all of those tools available to you so you can deploy them when you need to. I think the key point really is just that businesses really need to have a focus on the protection of their trade secrets, so that you have got the processes and the information in place to deploy as and when you need to rely on those rights.
Thanks, Mike. That was a really interesting discussion. And for any more information on what we discussed today, please visit the Wigan website.